Welcome back to Firepower. Let me start with a situation that feels uncomfortably ordinary. You're driving home. You get pulled over for a minor traffic issue. The officer is polite. You're polite. Then comes a question that sounds harmless, almost routine. Do you have any weapons in the vehicle? Most lawful gun owners believe this is the moment to be honest, cooperative, and transparent. They think the right answer will make the situation smoother. What almost no one explains is that this single moment is where more legal cases are lost than won. Not because a crime was committed, but because the wrong words were spoken. Today's video is not anti-police, and it's not about encouraging confrontation. It's about understanding how the legal system actually works, not how we wish it worked. A criminal defense lawyer would tell you this plainly. Your words are evidence. Once you say them, you don't get them back. And the roadside is not the place to explain yourself. This is a legal survival guide for lawful gun owners. We're going to walk through what not to say, why it's dangerous even when you're innocent, and what the safest responses actually are. This is not legal advice. Laws vary by state, but the principles behind these mistakes are consistent everywhere. Let's begin with a hard truth that many people resist. Police officers are trained to gather information. They are not there to decide guilt or innocence on the spot. That happens later, in an office, by a prosecutor who was not present for the conversation. Everything you say is filtered through that lens. Tone does not transfer. Context is optional. Words are permanent. Being polite does not mean being protected. One of the biggest misunderstandings among gun owners is believing that honesty alone equals safety. The legal system does not reward honesty the way people think it does. It rewards precision, silence, and counsel. You are not required to help build a case against yourself, even if you believe there is no case to build. With that framework in mind, let's talk about the most dangerous sentence you can say. Yes, I have a gun. This feels like the responsible answer. It feels cooperative. It feels transparent. But legally, it does one thing very clearly. It establishes possession. That's it. It does not establish legality. It does not establish compliance. It does not establish context. From that moment on, the government no longer has to prove that the firearm is yours. You just did that for them. If anything else about the situation becomes questionable, the foundation of possession is already locked in. In states with duty to inform laws, you are required to notify an officer that you are carrying, but the wording matters. The law often requires a specific notification, not a casual admission. Saying the wrong phrase can technically fail the legal requirement while still admitting possession. The safer approach when notification is required is to use the language the statute demands, nothing more. And when notification is not required, silence is almost always safer than volunteering information. The next dangerous statement sounds even more helpful. It's in my glove box. Or, it's under my seat. What you just did was establish immediate control and location. This is where many cases take a sharp turn. Firearm laws are often extremely specific about where a gun may be stored, how it must be secured, and whether it can be accessed from the passenger compartment. By naming a location, you may unintentionally admit to a storage violation, even if you had no idea one existed. Prosecutors love location statements because they convert abstract possession into physical proximity. Even if no charges are filed immediately, this statement can justify further searches, seizures, or temporary confiscation. You thought you were being clear. You may have just expanded the scope of the encounter. A safer response is not to discuss details at all. You are not required to narrate the layout of your vehicle. That information can wait for an attorney if it's ever needed. Another phrase people rely on is this: "I have my permit." This sounds like a legal shield. In reality, it's a verification trap. Permits expire. They get suspended. They can be invalid across state lines. Administrative issues happen without notice. Saying you have a permit is a factual claim that must be correct in every detail. If it turns out the permit is expired by a single day, suspended for an unpaid fine, or not recognized in that jurisdiction, you didn't just make a mistake. You provided false information to law enforcement. That can become a separate charge. Even worse, this statement invites scrutiny. It shifts the encounter from a general stop to a document verification process that may not have happened otherwise. A safer approach is to avoid making legal assertions about your status. Verification should happen through proper channels, not roadside explanations. Then there's a sentence that feels morally justified. It's for self-defense. This is one of the most misunderstood statements in gun law. You think you're expressing a lawful purpose. What you may actually be doing is introducing intent into the record. Intent is a powerful concept in criminal law. By stating a purpose, you open the door for a prosecutor to argue that you were prepared, expecting confrontation, or carrying with a mindset that escalates the situation. In certain locations or circumstances, this statement can elevate a simple possession issue into something far more serious. Intent is not something you want to volunteer, especially not without knowing how it may be interpreted later. One of the most common panic responses is this: "I forgot it was there." People say this to sound harmless, to sound absent-minded, to sound non-threatening. Legally, it's a disaster. Forgetfulness is often treated as negligence. Negligence destroys several possible defenses at once. You just admitted you knew about the firearm at some point. You admitted a lack of control. And you admitted unsafe handling, all in one sentence. This statement can undermine arguments about lawful transport, secure storage, or lack of awareness. In some cases, it transforms a minor issue into a chargeable offense. Now let's address the question everyone asks at this point. What can you say? The answer is less satisfying than people want. Very little. If your state has a duty to inform law, comply with it exactly, using the required wording. Do not elaborate. Do not explain. Do not answer follow-up questions beyond what the law requires. If there is no duty to inform, you generally do not need to answer questions about weapons at all. You can remain polite, calm, and respectful while declining to discuss details. The most powerful sentence in this situation is also the simplest. I choose to remain silent, and I would like to speak with an attorney. This is not an admission of guilt. It is not suspicious. It is the exercise of a constitutional right. Lawyers do this for a living, not because they are guilty, but because they understand how cases are built. There is a reason every defense attorney repeats this advice relentlessly. You cannot talk your way out of a criminal charge, but you can absolutely talk your way into one. Another dangerous misconception is believing that silence makes you look guilty. In court, silence cannot be used against you, but statements can. Jurors are instructed on this explicitly. Prosecutors know it. Defense attorneys rely on it. The roadside is not the place to fix misunderstandings. It is not the place to argue your interpretation of the law, and it is not the place to educate an officer on firearm statutes. Your goal in any police interaction is simple: End the encounter safely and lawfully without creating new problems. This is especially important for gun owners because firearm laws are complex, layered, and often unforgiving. Many violations are strict liability offenses. That means intent doesn't matter. Saying "I didn't know" doesn't fix anything. Understanding this doesn't make you anti-law enforcement. It makes you legally literate. Now let's talk about tone, because tone matters. Even when words are limited, you should always remain calm, always remain respectful, always follow lawful commands. Silence does not mean hostility. Silence paired with compliance is not resistance. It is professionalism. The biggest mistake people make is trying to be helpful beyond what the law requires. Helpfulness feels moral. Legally, it is often dangerous. This video is not about hiding wrongdoing. It's about not creating it through misunderstanding. Owning a firearm comes with responsibility. That responsibility includes knowing when to stop talking, knowing when to let the system do its job, and knowing that your lawyer is the only person whose job is to protect you. If there is one lesson to take from this, it is this: your rights do not protect you if you give them away voluntarily, and words are the easiest right to give away. Now I want you to think about your own situation. Do you know whether your state has a duty to inform law? Do you know the exact wording? Have you ever practiced saying nothing under pressure? These are not hypothetical questions. They matter in real life. If this video surprised you, share it with someone who carries legally. This information is rarely taught, but it prevents real harm. If you value clear, practical discussions about firearms, law, and responsibility, make sure you're subscribed to Firepower. We focus on understanding the system, not fighting it blindly. Stay informed, stay calm. And remember, the smartest sentence you can say is sometimes no sentence at all.